All right, we're back live tonight here on In Focus. We turn to this now. Lawyers for uMkhonto Sizwe have told the Electoral Court that the ANC's wish for MK to be deregistered is motivated by former President Jacob Zuma's support for the new party. Arguments were heard around whether the decision by the Deputy IEC CEO to overturn the initial rejection of the MK registration is lawful. Newzroom Afrika's Ziyanda Ngcobo reports from Bloemfontein.
The courts have again become the arbitrator of a political fallout. The ANC has approached the Electoral Court to have the uMkhonto Sizwe party deregistered before May's vote, arguing that the matter is urgent.
The court must ask itself, what are the consequences if it were to turn the ANC away? We say that there are three. The first is, in calm and several other judgments of the Constitutional Court, and in fact of this court, lawfulness of decision-making is placed at the center of a free and fair election. And we say that if you cast aside the rule of law in this particular application, there is a very serious and material threat to whether the elections that we're about to have on the 29th of May are in fact free or fair. This is because there are questions regarding the legality of a party on that particular ballot and whether that party should in fact be there in the first place. And so we say that's not an issue that the court should turn away from. It's the very thing that this court was established to decide, to protect free and fair elections, to protect the right to franchise, but importantly to uphold the rule of law.
The ANC also argues that the Independent Electoral Commission's Deputy CEO has no powers to overturn their initial rejection of uMkhonto Sizwe's registration as a political party by accepting a supplementary application.
Now, to get to a point where he reconsidered that application on the basis that it is supplemented, he has to retrieve that rejected application. He has to retrieve it and then reconsider. So effectively, he sits in a position where he reviews his own decision and reverses it. Because that's effectively what he has done. So we say he's not authorized by the Act to do that. That decision was done. That application became defunct. There was no application before him for further consideration. An application would come before him if a new application was filed, as he advised the third respondent to do.
But the IEC says the ANC has no say on how the initial rejection letter sent to the MK party can be interpreted, given that an understanding was reached.
The ANC cannot second guess what was intended to be conveyed and how it was understood. It is simply not a participant.
MK party advocate Dali Mpofu has raised arguments around jurisdiction, saying the ANC should have appealed to IEC commissioners first before approaching the Electoral Court.
Section 20, bracket 1, bracket A of the Act. The Electoral Court may review any decision of the Commission relating to any electoral matter. So to simplify this, let's not quibble about whether this relates to an electoral matter or not. Let's assume that is so without deciding. And we focus on these few words, that the Electoral Court may review any decision of the Commission. Is there a decision of the Commission before this court? No.
Mpofu contends that the ANC knew last November that the IEC rejected its appeal surrounding the logo and emblem used by the MK party. But the issue of registration was never in question until former President Jacob Zuma announced his support for the organization in December.
So what changed? The only thing that made them to wake up from their slumber was the announcement on the 16th of December by former President Zuma that he would vote for, or he would vote and campaign for the the MK party.
Judgment has been reserved. For Newzroom Afrika on Channel 405, I'm Ziyanda Ngcobo in Bloemfontein.